Minister, it's been a long afternoon for you, that I know. Your own remarks this afternoon were promising and encouraging that you're willing to go back and have a look and see what changes you might make. Senator McDougall referred to the impact on family and defamatory stories. You yourself made the point in your own response a little while ago that where a Garda investigation is taking place into an individual, it's in the public interest that that might get into the public domain, as it were. Is it really right that somebody who is being investigated for whatever reason, that goes into the public domain? Think of what happens with the family. First and foremost, the immediate family of the alleged person, let's say it's a child abuse issue. The immediate family have to cope with it, but then the extended family have to cope with it, then the community have to cope with it, then his employers have to cope with it, or her employers, and it becomes a massive, massive issue. Why? Because somebody indiscriminately passed on information that should never have gotten into the public domain. So I would be rather shocked if we were saying that it's not defamation to print something or to publish something that says an individual is under investigation. I'm going back to the story that I opened with last week in the Irish Independent article about a senior politician being involved in a charitable event and, of course, couldn't be named for legal reasons, but the story had originated with An Garda Síochána. First and foremost, it brings the Garda Síochána into disrepute. There are, as you pointed out yourself, there is a criminal case where a guard is leaking information. I haven't seen one. I think there might have been one case. Yeah. So it's a criminal offence. Yet we see this constantly in the media. Garda sources. In that particular story, I think they quoted 3 or 4 Garda sources without naming any. And of course, if you were to try and take a criminal case against that particular publication, they would claim journalistic privilege. I'm not releasing my sources. But believe me, I got the information from a guard. And I believe the information was true. You might never have gotten the information from the Garda. The Garda might know nothing about it. But that story was printed on that Monday deliberately to impact the election prospects of a candidate in the current presidential election. And that has to be a criminal offence, to actually try and influence the outcome of an election by printing a story that had no basis. And of course, the candidate in question had to make a statement the following day, which is rather sad that that's the way it went. Moving on to social media. Some of the stuff that's been said on social media about another candidate in the presidential election is absolutely outrageous. The claims that are being made as factual are absolutely outrageous. But again, the person making them is anonymous. It's the person Senator McDougall referred to sitting in his box room or wherever, publishing his blog that he or she believes is 100% accurate, 100% true. The people have a right to know. The people have a right to know. And what he or she is saying is being said in good faith. Looking at the Section 26 of the 2009 Act, you had some cover. I do believe that where we are now, the very little cover, you've got a number of hurdles to jump through before you can go anywhere with the thing. I've heard in this House statements that, particularly when we talk about migration issues, that lead to misinterpretation in social media, lead to all sorts of allegations, and we finish up with something like we had last night in City West. Again, statement made here might refer to 1 or 2 things, and it's taken out of context on social media. I was speaking last week about the teacher that was accused of interfering with a child. And some years later, it turned out that there was no interference with the child. And the teacher in question looked for a timetable. And the school were somewhat reluctant, based on the sort of there's no smoke without fire. There had to be something, even though the investigation showed nothing. And I was discussing this at the weekend with some friends. And I was saying it was outrageous that that teacher was not immediately handed their timetable and reinstated on the staff. And the answer I got back was, well, hang on a minute now. That school probably had 300 or 400 parents who were concerned. And the concerns of the parents had to be taken into account before the teacher would be reinstated. I had an uncle one time, and he had a saying, the sped arrow and the spoken word can never be retrieved. And I believe the same applies when it comes to the written word. Now, you rightly point out we all have recourse to the courts. Recourse to the courts to find out who on social media has just made some outrageous comment about one or other of us in this house or a member of the public. Not everybody can afford to go to the courts. Going to the courts is not for the faint-hearted. And why should we have to go to the courts to find out who's making statements about us? Why isn't it mandatory that if you're using social media, you can use any ridiculous name you want, but your full details have to be available in the event of a statement being made? So as anybody in this house can go to the Gardaí and say, the person using this particular handle on social media is making outrageous claims about me. Go and do something about it. Are we afraid of the social media companies? They're the ones with the money. They're the ones that should be held liable for what's published on their platforms. And I don't know why they are not. And I just make one last comment, because I do know you've sat through quite a lot this afternoon. We all in this house are getting emails now on an almost daily basis. There are some people who write to me, and because I look at the email address, they're writing to everybody in the house, and they're making outrageous claims about ministers, about the president, about the European Union, about all sorts of things. Right? Is that publishing? Once it's more than one person, it's not an email to me, it's an email to the entire houses of the Oireachtas. Is that regarded as publishing? And if it is, what recourse has the President of Ireland or the Commissioner in Europe got against that person? And they're fortunate insofar as they can afford to take them on. What's the point in taking on somebody who has nothing? What's the point? I don't know if you remember, there was a senator here who was subjected to horrendous interference and what do they call it, trolling on the internet, and she eventually got the case into court. They eventually identified the individual, but he was brought into court on criminal charges. Same guy hadn't two red cents to rub together when it came to defending her name. So defamation, I think it's for the brave, anybody who wants to take it on, but we should set the bar high for those who publish. And the Dúirt van Lum, go Dúirt van Leahy type of defence is simply not good enough in my belief. So I'll leave it at that, Minister. Thank you.
Thank you very much, Senator Craughwell. And if there's no more members offering, we'll go back to Minister O'Callaghan.
I want to thank members for their contributions, which I've listened to very carefully. But to start with Senator Ruane, if I can. Senator Ruane made a number of interesting points. Her first point was about non-disparagement clauses, and she was inquiring as to the interlink between non-disparagement clauses and the defamation laws that operate at present. My own view, Senator, is that there isn't a link between the two of them. If somebody has signed a non-disparagement clause, say with a former employer, that doesn't restrict them from making defamatory or comments about the employer in defamation. However, it does restrict them in terms of the provision that exists in contract. So if it was the case that a former employer, as you gave the example of, say, a delicatessen with foods that were completely inedible and were in breach, say, of safety regulations. If somebody worked there and had signed a non-disparagement clause, there's nothing in the law of defamation that precludes them from making comments accurately about the condition of the deli, stating that the food there is in breach with food and safety laws. But they probably would find themselves subject to a claim for breach of contract or even an injunction to stop them because they're not complying with the non-disparagement clause to which they had agreed. So I suppose if people agree to them, it can have consequences in terms of restricting their freedom of expression. But the defamation laws aren't the laws that interfere with that defamation or with that freedom of expression. You also asked about non-disclosure agreements and the use of them in references. If somebody's writing a reference and in respect of a former employee who they believe had harassed or bullied colleagues, they're perfectly entitled to say that in the reference. If it's true, and they're perfectly entitled to say that under the defence of truth. But as I said earlier on, generally anything contained within a reference, provided that reference isn't malicious or disproportionate, is protected by the law of qualifying privilege. You asked about the example of, say, somebody gives a false reference. If an employer, in fact, knows that the employee was involved in bullying or harassment, but decides, in order to get them off the books, to give a good reference. The only liability that arises there is that the new employer may have an action in negligence against the old employer who gave what was an inaccurate and dishonest reference. You also asked, Senator, about more vulnerable people. My own experience is that very many people who fit within the description of vulnerable people have taken defamation actions and have succeeded in them. Certainly I'm aware of very many people who had criminal convictions who've taken defamation claims and have succeeded in those defamation claims. There's also a reported judgment, which obviously I'm entitled to refer to as a result of that, called Hill against the Examiner, where a man who was a prisoner in Cork prison, he was a prisoner and had a conviction for serious assault, but he was identified in a newspaper as being in a section of the prison which accommodated persons who were guilty of sexual assault. And he took an action in defamation and he succeeded and was awarded significant damages. So it is certainly the case, in my opinion, and experience, that people who have convictions or people who were or indeed are prisoners are just as entitled to take defamation claims as anyone else. Obviously your reputation is damaged as a result of getting a criminal conviction, but that doesn't mean that you've lost your reputation completely. There are different gradations in terms of damage to your reputation. You also asked about the right of reply. Obviously, in terms of the Press Council, if somebody doesn't issue a defamation claim but they decide to go down the route of the Press Council can require the publisher to issue a right of reply. There's also a provision within the Defamation Act that isn't affected by this bill, which refers to the right to make amends, where a defendant can say that they have made amends to the person who was defamed. You also asked in terms of the public interest and how the legislation talks about, is it for the public benefit or is it in the public interest? The new provision simply limits it to the public interest, and I think we're better off not having sort of different types of standards, public benefit and public interest. I'm trying to simplify the Section 26 defence, and that's part of the reason why we've removed the section that the publication be of public benefit as well. Then, just to deal with what Senator Mullen stated in respect of his contribution. Senator Mullen spoke about Section 26 operating in a preventative way, and that he wants to ensure that it continues to operate in a preventative way. Like, that's not the intention of it. It's not there to prevent stories being published. Like, we have the other aspects of defamation law to deal with that. We have the provision dealing with its defamatory statement to say something that lowers a person's reputation and the right of reasonable members of society. So the rest of the Act sets out the protections for the right to one's good name. So Section 26 isn't supposed to be there to prevent people publishing stories. As I said at the outset, it is there to ensure that articles which are published in the public interest and in respect of which the publisher has gone to lengths to ensure that they've sought to check their sources and verify the story, that has given some level of protection. And I suppose the example that was, where I think Senator Mullen asked me, can you provide an example of what would, where this section would apply? Like as Senator McDougall mentioned, I think the Adams case was a case where Section 26 had been invoked but wasn't invoked successfully. But you could certainly think of situations where a broadcaster or a newspaper has done a thorough investigation into something which is clearly in the public interest. Let's look to see the performance of functions by a statutory agency. They're able to establish that there were deficiencies in what the statutory agency was doing and that it wasn't fulfilling its statutory role. It was having a significant negative impact on the public, and clearly a story that was in the public interest. However, within it, they may have stated something that wasn't correct in respect of, say, an official who was either at the senior management within the statutory agency or someone on the board of the statutory agency. Now, that may be very troubling for the person who can say, listen, that I wasn't responsible in any way for that. But the purpose behind this is to provide some broader protection where the substance of the story is true, but one part of it is wrong, and the publisher has gone to significant lengths to ensure that it was properly inquired into and investigated. Senator Mullen also spoke about Section 26(3), where he expressed concern about the fact that the court shall, in determining whether it was reasonable for the defendant to believe that published statement was in the public interest, disregard any omission of the defendant to take steps to verify the truth of the imputation conveyed by it. And this is in respect of which the defamation action was brought when it was an accurate and impartial account of a dispute. So the first instance, there has to be an accurate and impartial account of a dispute. And indeed, Senator McDougall previously said, well, what are we talking about here? We're trying to provide some form of statutory protection here to, I suppose, the reporting of circumstances such as following. If there was a dispute in government between two ministers, one minister said he believed the other minister had met this individual, was fulfilling a part of his ministerial function. The other minister denied this. There was a significant dispute between two ministers in respect to this matter. Like, from a newspaper's point of view, it is in the public interest that they're able to report the fact that there is an ongoing dispute between two ministers, and it could alternatively between two senior officials in a statutory body. But I suppose the fact that they can report that is in the public interest. But what we're seeking to do here is to say that, well, they don't have to identify which one of the disputing ministers or officers in the statutory body are correct. We don't have to go and check with each of them as to whether or not they made efforts, or the publisher is making efforts to try to figure out the truth of it or not. The story itself, the fact that there is this dispute, is in itself in the public interest and should be reported without the necessity, as is generally the case, of them having to verify the truth of the imputation conveyed by it. So obviously the truth of the imputation by the minister, in my example, is that the other minister had been involved in wrongdoing by seeking to meet this other person whom the other minister denies that they met. So you can see the purpose behind which this provision has been drafted, and is designed to deal with disputes that clearly have to be in the public interest. Senator Mullen also mentioned about the watchdoggery, and he referred to selective watchdoggery. It's unquestionably the case that newspapers in Ireland don't have to be impartial or objective. There's no requirement on any newspaper to be impartial or objective. They can be as completely biased as they want to be, and that applies obviously in respect of online publications as well. The only time the state imposes an obligation on a publisher or a broadcaster to be impartial as objective is if we're providing them with a licence. And if you look at the Broadcasting Act, obviously it imposes obligations on broadcasters to ensure impartiality and I think fairness in the treatment and broadcast of current affairs. So we have to recognise newspapers, they can really have a political agenda that suits them. They don't have to be fair. They don't have to be unbiased. They're entitled to put forward opinions that other people disagree with. It was also, I think Senator Mullen mentioned the case of Father Reynolds. Like, that is an example of where somebody who doesn't have much wealth or much influence, but was the subject of a very significant and damaging and defamatory story, was able to vindicate his good name because of the defamation laws. That won't change under the current legislation. Senator McDougall then came in and he started by mentioning a third form of canine that I won't get into that's been mentioned today. But he probably makes a valid point in stating that with juries gone, Section 26 will probably become more navigable. The judge hearing the case will be able to apply and operate the difficult statutory scheme in a more navigable way than would be the case with a jury. Senator McDougall recommended, and I know he's just putting this forward as a recommendation, I'll consider it, but his proposal would be that I remove Section 26(1)(c), which imposes the requirement that the publication, in all the circumstances of the case, it was fair and reasonable to publish the statement. I just want him to note, however, though, that if that is removed, then my understanding is all of subsection 2 would be removed, because subsection 2 says the following: for the purposes of this section, the court shall, in determining whether it was fair and reasonable to publish the statement concerned, take into account such matters as the court considers relevant, including any or all the following. Yeah, so I will go back and reflect. I like the idea of having a provision that is just reflective of Section 26(1). I think Section 26(2) makes it a very complicated and difficult statutory defence to operate. I hear what Senator McDougall says in respect of Section 26(3). Like, my own assessment in respect of that is that it is not going to mean that if somebody doesn't reply that it's an inference that they're happy with it. That's not the case. The court has to deal with if you look at the provision that's going to be there, were such inquiries and checks as it was reasonable to expect of the defendant. That means something. And so there have to be reasonable inquiries and checks made by the defendant seeking to verify the story and the truth of the story. I agree with Senator McDougall in respect of his comments about Mr. Robert Dorr, one of the finest defamation solicitors we have in the country. I also recognise what you say in respect of stakeholders. It is a term that I use, and it's one of these things when you become minister, you get words that you find yourself having to use. But in terms of the real stakeholders, the stakeholders when it comes to any legislation are the people, the citizens of Ireland, and their representatives are in this House and in the lower house. So the primary stakeholders and the people who determine law are the elected representatives. It is nonetheless the case, however, that very many individuals will have an involvement in particular aspects of legislation. And it's unquestionably the case that newspapers, the NUJ, and indeed lawyers, but lawyers in their capacity as representatives of litigants, will have an ongoing interest and involvement in this matter. I don't think there is any downside to hearing the feedback from people who are practitioners. I'm well aware, as everyone else in this House is, that when you get a communication or a representation from an entity, and as members of the Oireachtas, we all get a lot of them, they all come with their own agenda. And I'm fully aware of the fact that the newspapers have an agenda, and their agenda is to ensure that they can have greater flexibility to publish, and they want greater defences when it comes to defamation claims. Just because they have an agenda doesn't mean that I can't agree with part of their agenda. What I have to do is to try, as I've said before, balance up the right to protecting one's good name and the right to freedom of expression. I will not allow myself to be planted into one group exclusively or the other. And I think newspapers should also recognise that there's an obligation on this House to respect and vindicate the good names of individuals. I also think it has to be said that, in general, we have a very responsible media in this country. I'm not including social media here, but in general we have a very responsible media. We don't see the type of wild stories that are sometimes referred to in the debate here or elsewhere, such as X is a child abuser. That doesn't happen in media in Ireland. Part of the
It did last week.
Well, we'll come back to that. But part of the reason why the media in Ireland are responsible and careful is because of the defamation laws. And the defamation laws have had, I believe, a positive impact on Irish journalism and Irish media, because you know if you read something in a respected Irish newspaper that it's going to be to a large extent true, and if they get it wrong, that will be established fairly promptly. A note in terms of the point Senator McDougall was making about the Press Council. I think it is preferable if the new Section 26 isn't just limited to people who decide to become part of the Press Council. We need to ensure that if there's a statutory defence available, it should be broadly available to anyone who comes within the parameters of the defence. I think it is important that we don't just limit this defence to journalists. We all know the world is extending. There are activists, there are people involved in academia. We talk about the person in the room on his own with his computer. Just because he's in the room on his own, if he complies with the test, if he prepares a well-researched publication, if he makes the effort to ensure, if he makes the necessary inquiries and checks that was reasonable to expect of the defendant, if what he's publishing is on a matter of public interest, if he reasonably believed that publishing the statement was in the public interest, and if the statement was published in good faith, well then, yeah, notwithstanding the fact that he's up in an attic, he will get the benefit of that defence. And I think he should be entitled to that defence in the same way as an editor of a newspaper sitting in a larger office will be entitled to the benefit of the defence as well. So we can't assume that just because somebody is a solitary sole operator that their intentions will be malign. Again, the test should apply across the board. It is hard to give examples, I suppose, of the type of defence that would operate or how it would successfully operate. I don't like referring to cases, particularly as Minister for Justice, but as I said earlier, it was the case that the case brought by the BBC didn't succeed in their case, and their defence that was brought against them by Gerry Adams. But there has to be some cases out there that will get the benefit of Section 26, and it hasn't happened to date. And if it's been there for 14, 15 years, it's surprising that there hasn't been a successful vindication of that defence to date. I note what Senator Mullen said in respect to that. I don't think it's the same as saying, oh, there hasn't been a prosecution, it isn't working. Like where there has been many defamation claims, and there have been many examples, I'd say, of where Section 26 has been pleaded and relied upon, it is surprising that we're not able to identify one example of where it has succeeded. I think it's important to note as well that the Justice Committee made a recommendation that Section 26 should be simplified. That was the report of the Oireachtas Just Committee. So I know what Senator McDougall says about the Dáil being quiet about it, but they did have an opportunity in, I think it was pre-legislative scrutiny, or it was the review, I think, of the Oireachtas Committee's report. They did have an opportunity to look at this. I'm trying to see, did I get on to dealing with Senator Craughwell? I'm coming to Senator Craughwell now. Yeah, sorry, I'm coming to Senator Craughwell presently. Can I just look at section 26(1) as it exists at present and compare the new section 26(1)? Like the substance of the current law is set out in section 26(1). Section 26(2) is just providing examples that the court should take into account. And section 26(3), I think, is saying something that doesn't necessarily have to be said. So the substance of the defence is 26(1). And at present it says it's a defence to prove that the statement in respect of which the action was brought was published in good faith. And that's in the new provision as well. In the course of or for the purpose of the discussion of a subject of public interest. And that's in the new provision as well. And then it continues, the discussion of which was for the public benefit. Now that has been removed, and I think the reason it's been removed, as I explained earlier in response to Senator Rowan, it makes it very complicated to have that addition in. And then the third one is, in all the circumstances of the case, the manner and extent of publication of the statement did not exceed that which was reasonably sufficient. Now that isn't included in the new one. And the last one is, in all the circumstances of the case, it was fair and reasonable to publish the statement. And what we've got is, in the new provision, the defendant reasonably believed that publishing the statement was in the public interest. So, as I said, I will reflect on that to see whether it's necessary to include the word fairly again. But it's also important to note that subsection 2 of the proposed new section 26 says that for the purpose of determining whether or not the defendant reasonably believed publishing the statement was in the public interest, that belief must be arrived at after the making of such inquiries and checks as was reasonable to expect of the defendant. So it is not a million miles away from what is there at present, but it is an effort to try to make it more manageable. I note what Senator McDougall says, that there wasn't not one comment of this debate has been published. Again, that's reflective of the fact that newspapers don't have to be objective or don't have to cover debates that you may believe is important, but they decide for their own interest that they don't wish to cover. Nonetheless, I suppose it does show the usefulness of the upper house that we're having a very detailed discussion about this. I note also what Senator McDougall says about a report stage. I didn't know that, but what I will do, I'm not guaranteeing anything, I will go off and I will consider whether any amendment can be brought in just to take into account what senators have said here. I just finally want to deal with Senator Craughwell. I just want to clarify, Senator, I didn't say it was in the public interest that the Garda investigation would get into the public domain. I said the defence of truth allows it as a defence to say, well, in fact, there is a Garda investigation. I clearly recognise that that can be a breach of statute and a criminal offence, and it can also constitute a breach of a person's privacy. Senator Craughwell spoke about the impact on families. That's certainly the case, and it is why we have, I suppose, in part, it's part of the consequence of defamation that isn't really recognised in our statutory scheme. There have, however, Senator, been prosecutions for the release of information from Garda Síochána about investigations, and there's also been convictions. You spoke about social media, that there's outrageous publications on social media. That is the case. And in many instances, if somebody wants to get information about the publisher on social media, at present they have to go to court to get a Norwich Pharma order in order to get the details. So, like you said, they can use whatever name they want. Ultimately, people will still have to apply to the social media company to get the details identifying the publisher. Social media companies say that that has to be through a court process because they want the protection of a court process. And that, eventually, when we get to it, is apparent from the new statutory scheme I'm introducing later in this bill. You talk about emails coming in making outrageous allegations. Unfortunately, we live in a world where lots of people make crazy defamatory publications about people. You know, they are, if it's published to one person, it's defamatory, but because of the proliferation of defamatory publications, a lot of us don't bother doing anything about them. And I used to think people believe everything they read, but as time goes on, I think people are becoming more discerning and recognise that not everything they read is true. Thanks very much. So I will actually push Section 11 to a vote, Gerard.
Please.
Thank you very much. Minister, you said that social media would never accuse somebody of being a child abuser. I was accused of being a child abuser. Well, I was, and I've also accused of being responsible for the deaths of 50,000 babies in recent weeks, which is why I closed down my Twitter account completely.
It's an ordinary media.
Okay, maybe I misread what you said, but Minister, the bottom line on it is, when you talk about social media, and I know that's coming later, you contact the likes of Twitter and make a complaint, and you find the most outrageous things they're not against their rules. And bottom line on it, I personally have no interest in it anymore. But I go back to the impact that wild statements have on families. Yesterday I brought up the issue of migration in this country. Constantly we're hearing, oh, they're rapists, they're this, they're that, they're the other. I made the point yesterday there were 6,683 rapes in 10 years in this country. I think it would be no harm, Minister, if your department published the nationality of those who were convicted of rape and maybe put an end to those type of wild stories. And you mentioned the flood of emails. I don't read them, and I sincerely hope most of the people in this House no longer read them. If I get an email, dear member, I just dump it. I don't read them anymore. So from that point of view, but it is interesting that they can be defamation. I have serious issues with the good faith and public interest. How do I prove that somebody, or disprove that somebody wrote something in good faith? How do I say that something is not in the public interest? I mentioned the Irish Independent article. That was deliberately written to impact the current presidential election. Are we at a situation where, allegedly that story originated from the Garda Síochána, are we at a situation where a member of the Garda Síochána can decide that I don't like Michael McDowell, therefore I will publish something and make sure he's never elected to the House again? Particularly when you're talking about young politicians coming in here in their first term who have, I've seen some wonderful work by some of the young politicians that have been recently elected. All you need is somebody to print a story based on some innuendo that some guard said something. And as Senator McDowell says, if this bill passes, you can now name him. And of course, the journalist will say, I'm not disclosing my sources. So that's the concern I have, and I'll leave it at that.